Good afternoon. Welcome to Tuesday's webinar. Today, Matthew Grumbling is going to be talking about copyright pitfalls. I'm going to talk about where you can get in trouble and definitely on how you can avoid it. Hi, Matt.
Hi, Julie. How are you doing?
Great. How are you?
Good.
So I believe we're probably about halfway through the copyright series.
That's about right. Yep.
So as most of you that have attended these, you already know, we do record all of our webinars so that you can actually go back and watch them again or refer them to somebody else that may need this information. You can find them on YouTube on the City of Surprise Economic Development channel. And I will just go ahead and let you take it away.
All righty. Thank you, Julie. So again, my name is Matt Grumbling. I'm with Nguyen Tarbet LLC, which is we mostly do patents and trademarks and related licensing and things like that. We're affectionately known by our clients as NTIP. And my contact information is up here, Matt and NTIP or ntiplaw.com. And there's my cell number. Feel free to call anytime you want. Just know that I may not answer. I may be on the line or something like that. And if you leave me a message, even if it's a short one, I will get back with you. I should add a disclaimer at the beginning that this is all for educational purposes. And I'm not offering legal advice, but I'd be glad to give you a free consultation if you call or email me. But what we're doing here today is not intended to be legal advice, and it's not intended to form a relationship between us. And I'm sure you already know that, but it's worth saying up front. Also notice that I finally got around to putting a copyright notice at the bottom of my presentation here, and we'll talk about whether that will be effective or not as we go along through this presentation. So the title of today's presentation is Copyright Pitfalls. Copyright pitfalls, what are we talking about there? They're just the kind of things that can get you in trouble as a business owner with respect to copyrights, both as a copyright owner and potentially as a copyright infringer. So here are the topics that I'll cover today. First off, I'm going to do a little bit, I've kind of in previous slide decks presented the conceptual framework, but I thought I'd better hit some things, at least at a high level, again, before we start launching into the mistakes that people make. Categories of copyright protection are within that conceptual framework. What can't be copyrighted, and also fair use. Some of you may have heard that term of fair use. Oh, it's fair use. Well, is it or isn't it? That's a good question. Then I want to cover some general mistakes that folks make, and then I want to cover the big mistake, which is infringement. And there are mistakes actually made on both sides. There are those mistakes made by accused infringers, and there are those that are made by the copyright owners, who would be the plaintiffs normally speaking of mistakes, I'm making mistakes in controlling my mouse here. Plaintiffs. So anyhow, we'll talk about both defendant and plaintiff side mistakes. So here's we'll talk about the conceptual framework. So just as a reminder, this is more review than anything else. There are several categories of copyright protection, and your particular expression or your particular piece of art or your particular software may be covered by more than one of them. So we can talk about those a little bit, but just to refresh your memory, there are things like literary works, like books and magazines, journal articles, things of that nature. There are musical works, including accompanying words. There are dramatic works, including any accompanying music. There are pantomimes and choreographic works, things like dances, etc. There are pictorial, graphical, and sculptural works. There are motion pictures and other audiovisual works. Some of these are rather self-explanatory. They're sound recordings. Believe it or not, before 1978, sound recordings themselves were not covered. And there are architectural works. And I'm not going to go into detail on architectural works. It's a bit of a complex area. But if you have a question about architectural works, feel free to give me a call or shoot me a quick email, and I'll be glad. And also, if you happen to text me on that cell phone, just kind of give me an idea who you are, so that I'm not like, who's this? Okay. So what cannot be copyrighted? Well, you can't copyright procedures, processes, systems, methods of operation, or discoveries. And part of the reason you can't protect these with copyright is because they're already covered by patent law. And they're just a different category of intellectual property, and Congress has decided to cover them differently. I suppose I could imagine a world in which they covered them both with the same statute, but they didn't. They clearly demarcated patents off from copyrights. And we'll talk a little bit about how they might overlap later on. Then there are ideas, concepts, or principles, and those are generally they're not protectable by copyright, although to the extent that they're expressed in a particular original way, and in a particular creative way, they can be protected, but the ideas themselves cannot. So I'll just give you what I think would be a fairly trivial example, and let you kind of run with this. But let's say I'm Albert Einstein. Obviously not. But if I were Albert Einstein and I thought of the idea that energy and mass can be related to one another by the square of the speed of light, and I were to write that out as equals mc squared, that's not really copyrightable as an idea. Although if I wrote a paper on it and published it in a journal, that journal article would be protectable. So I think that's an important point there, that even though the concept or the principle is not protectable, the expression itself is. So and this is a very common thing in universities, that all of their journals are available to the public to come in and read and make copies and whatnot. But in order to have the copies made, you have to fill out a form and take it to a central area where the copies are made. At least this was true when I was in the university. You had to take it. Now, if you were a student, it was a different thing, but maybe. But if you were a member of the public, you had to fill out a form, have somebody make the copies for you, and then you would either pay the 25 cents or whatever per copy that's made. You might think, well, that's pretty steep for a copy. Well, a portion of that is going to pay for the copy that was made, and that's a fairly common arrangement between universities and these publishers of various journals. Part of the deal they get when they sign up to, say, get the Journal of the American Medical Association, JAMA, or the Journal of the American Chemical Society, that these copyrights will be respected. And honestly, the authors oftentimes pay really large amounts of money to have their publications made, or at least their institution, their granting body pays a lot. So, again, there is protection in the expression itself, but not the idea itself. So if somebody else took Einstein's idea, equals mc squared, and turned it into a nuclear power plant, guess what? All he can get is the whatever money he might collect for selling the journal article in which the in which this was described. He can't go out there and now he would have to get a patent in order to take advantage of that application. So I hope that's clear. And just to be clear, an original work of authorship is something that's not copied from somebody else. That means it's original and it has a minimal degree of creativity, and that's the authorship part of it. Okay. And we'll just break this down a little bit more. Originality and authorship. Originality just means you didn't copy it from somebody else. And, NB means nota bene. It means note well that a copyright does not cover independent creations. What does that mean? Well, it means if two people are working on the same idea and somehow they manage to write something, let's say we're working on a song about the recent election. Well, I don't know why we would do that, but let's say we're doing a parody song, and we both both used the same basic idea and same chord progression, etc. But we did it completely independently, and there was no copying. We couldn't sue each other for copyright infringement. It just that wouldn't be available, because independent creations, like non-copied creations, they get their separate copyrights and they don't actually overlap with one another. I might make it difficult for the people who might be infringing our works, but it's fairly simple between A and B who both create something that seems very similar. Authorship requires a minimum degree of creativity. So in a sense, if you don't use a minimum degree of creativity, you're not really an author, you're just a scribe or a cleric. What do we mean by minimum degree of creativity? Well, it's something more than just making an alphabetical list like a phone book, okay? Things like mathematical formulas and natural laws aren't covered. So, I used E equals mc squared there. Energy is equal to mass times the speed of light squared. Well, we could have picked any combination of letters there to represent energy, mass, and the speed of light. You might wonder why the speed of light is c. I honestly don't know, but I probably did at one time. But why did they pick c? Well, s was already taken, I suppose. So and so was L, and so was lambda. So what's left over? We got C. But somebody could come along and say, well, E, E could mean something different. So I'll pick G and P for mass, and you get the idea. Those are rather arbitrary, and they're just not, they don't rise to that level of creativity. That is what I should say. Keep in mind, though, that even though mathematical formulas and natural laws aren't covered, a book or a video or a song explaining them or about them would, and don't, I know songs sound silly, but I learned a fair amount from Schoolhouse Rock when I was a kid, so which is probably pretty evident. Anyhow, keep that in mind, that there has to be some originality and authorship. So the next thing I'm going to talk about here is fair use. And you may have heard, it's not copyright infringement because it's fair use. So what is fair use? And is it really fair? And, what kind of uses are excluded from, basically copyright infringement liability, because they're considered by Congress to be, and these are concepts that Congress has decided are fair use. Okay, so these are defined in the statute. One thing is criticism, and that would include parody. And we'll talk a little bit about that later on. Another is comment or commentary. You know, there's a lot of, you know, if you're commenting on somebody else's work, then, you know, let's say you're, you know, writing a column on a movie, you know, that does movie reviews. You know, that might be covered there. News reporting. You know, if you happen to be reporting on the news about the theft of a very famous painting, and you happen to show, you know, incidentally, with that news reporting, you know, show that painting in the background or something like that, you know, that's fair use. Teaching. Teachers use a lot of different things in the classroom that are they're covered by fair use. Now, not everything is covered by fair use there, and you know, you'll notice that there's a good, you know, copyright notice in the front of just about every book that it finds its way in the hands of students. But there are some uses that can be considered fair use in teaching. You can make multiple copies of things for classroom use. I can remember reading a couple of copyrighted materials. I'm sure they were copyrighted when I was in school, that teachers had kind of just burned off on the photocopier and handed out. Scholarship. Now, again, you know, if you're studying something, you might need to make some archival copies of pages of documents that you have that you're citing in your work, and you might need to keep them, or you might need to quote them in your in you know, in your scholarship, and those quotations, of course, would be covered by fair use. And then there's research. So I think I've covered all of them there. These are all the statutory categories. You still have to consider to determine whether something is fair use. It's not enough that it fall into one of the categories. There has to be an analysis made of the purpose and character of the use, including whether such use is of a commercial nature or is for profit or for nonprofit educational purposes. So bottom line is, not everything that then hits one of those categories is going to be a fair use if basically what you're trying to do in making the copies is to avoid paying the author what the author deserves for having created this new creation. We need to look at the nature of the copyrighted work. You know, like for instance, maybe a sculpture that's being studied in a classroom. Maybe the kids might take a picture of it in order to have reference to it later on in you know, taking their exams. You know, they might need to have those photographs, whereas if somebody made photographs and then put them in a magazine and sold that magazine for money, that would not be fair use. And then the amount and substantiality of the portion used, that's a big one. So if you take some quotes from whatever book you happen to think of, and as long as you attribute it properly and, you know, do all the stuff you need to do not to commit plagiarism, that in general, you know, if that's even if it's for money, if you don't use a substantial portion and it's a legitimate use of it for criticism or something like that, you're probably okay there. And then the effective use upon the potential market or value of the copyrighted work. And what they're getting at here is you don't want a situation where somebody could just reassemble, say, Mark Twain's Huck Finn from the Huckleberry Finn from it's some book on, you know, that claims to be a criticism, but really basically copies the whole thing verbatim. And that would be, you know, taking the form over the substance, really. And what they don't want you to do is precisely that. They don't want you to be able to substantially copy an entire work, or even a good portion of it, creative portion of it, and make money of it without having contributed anything of your own value there. Like, So, and we could go into a lot of different scenarios there. So fair use, and I don't know why this is in there exactly. I think it's to address probably some issue that came up in litigation at some point. But just because something's unpublished doesn't mean that that using it isn't fair use. And that probably comes in where there's been some misappropriation, and there might be a state law claim for misappropriation there. So let's talk about some general mistakes people make. And these I think might illustrate some of those basic ideas a little bit more clearly. Let's compare. One mistake people make is they get copyrights and trademarks mixed up in their heads, and sometimes with some pretty negative results. So just remember that copyright requires original authorship, and authorship requires a minimal degree of creativity. On the other hand, and it requires more than a sentence or two. If it's in writing, it probably, since a picture is worth 1,000 words, probably one photograph would be, unless it was just, I don't know if it were just like a blank white sheet of paper or something like that, maybe not. But, for writing, it probably requires more than a sentence or two. A trademark can just be a single word or a symbol. And the symbol can be very abstract, and as long as it's associated with an article of commerce, either a thing or a service, the trademark it is valid, and it can be registered as well. Copyright covers the original expression, whereas trademark is an indicator of source. And I think that's really important because copyright bars just about any unauthorized use of the original expression, subject to the exceptions of fair use and basically fair use. Trademark covers a word or symbol only in the context of commerce, and specifically for the offer of goods or services, and the particular ones that the trademark is usually associated with. So, just maybe as an example, I'll raise the situation where a copyright would protect a logo that's on a shirt as an expressive element of that shirt. And not only would it cover the shirt, it would cover, say, if there were transfers used to make the shirt, or there was some, prototypes or something like that out there, but where there were drawings that showed this logo. Those would all be covered by copyright, and presuming that there was a copyright notice on there and everything else all those other conditions were met. There's a valid copyright in the logo as an expressive element. Trademark, and keeping in mind it has to be creative, right? So there has to be some minimal degree of creativity there. Now the trademark would only cover the logo on the tag, which is on the back of the shirt, which usually is used to show that the source is whatever the trademark is. So it identifies the source. So the copyright that would cover it there as well, actually, because it's a copyrightable element, but the trademark would only cover the use in commerce. Now, some shirts, I'm sure you've seen these, like Izod's or Polo, they have a little thing here, a little logo that indicates that it's Izod or it's Polo or whoever it happens to be. Well, that could also count as a trademark, because that's the kind of where you expect to see a trademark on a shirt, and it's an expression of it basically marks it as being made by whatever company put that logo on there. But a giant Tommy across the front of your shirt, that might not be considered a logo or a trademark for trademark purposes. It's really more of an expressive element, and it might be covered by copyright, but it's not covered by trademark. So these are things to keep in mind. And again, when I say that it could be copyright, it still has to meet that minimum degree of creativity. So, you know, somebody, either a judge or a jury, would have to decide, is Tommy creative enough to be copyrightable? So let's talk a little bit about copyrights versus patents. What's covered by copyright is that it protects the original work of authorship. Patents, on the other hand, cover useful, novel, and non-obvious machines, manufacturers, processes, and compositions of matter. So you can see there, these are two entirely different categories. Also, how they're created is really different. Copyright is created by fixing the original expression in a tangible medium, and patents must be examined and granted by the USPTO. So the process of getting a copyright and having it and being able to enforce it are completely different. Now, the copyright, I should add, is greatly enhanced if you register it, but when you register it, that's another question. In fact, another difference here is, copyrights may be registered at any time after their creation, whereas, just an example, and this is fairly common actually, is that, the registration will be filed with the Register of Copyrights right before an infringement suit is filed. And, and then later on, the complaint will be amended to include the registration certificate when it comes in. Patents have to be filed on time. And on time means before somebody else files on the same invention or discloses it to the public. And I'm speaking a very high level generality there. There's some exceptions and things, but basically you can file on a copyright anytime, pretty much until the copyright expires. You can't do that with patents. And by the way, copyrights last way longer. They also cover a lot less than patents do, at least conceivably. So those are some differences between them, and you want to keep those in mind while you're deciding how to protect your intellectual property. You got to ask yourself, what am I really trying to protect here? Is it a process? It's a process, then copyright's not going to give me a whole lot of protection. At best, it might cover the expressive elements within that process. But since, listing out a process is a lot like listing out something by alphabetical order, it may not have the level of creativity necessary to rise to the level of copyright. And one thing you probably can't do is, let's say you publish a cookbook, and the cookbook may be covered by copyright, but you can't prevent somebody from buying your book and using it to, using the recipes therein to prepare a meal for their family or somebody else. A patent, on the other hand, if you were able to get a patent on a process of making food, you could prevent other people from making food by that same process. So they definitely are different things, and you want to think about that when you're in it. And it all has to do with what is the economic basis of your business? Is it more, no, I like to create recipes and I want to publish them, and I like to put them in there with pretty pictures of the food and whatnot. That's how I'm going to make my money. Great. That's it. And then you're in the realm of copyrights. On the other hand, if you're into mass producing dessert products, you probably want to think the patent route, unless you can protect it completely trade secrets, which is another option. Let's see, there is an overlap between copyright and trademarks. There can often be overlap. It's very context dependent. The one example I've already used is, you have Tommy emblazoned on a shirt as a design element. That would be more of a copyright thing. If you have Tommy, maybe, if it's, I'm not sure it's sufficiently creative, but it may be copyrightable. But Tommy on a shirt label is an indicator of source. I'm fairly certain is a valid trademark, and well, I shouldn't say it's valid. That would be illegal. It's a trademark, and the patent office the patent and trademark office would be very likely to accept that as a trademark. And by the way, the patent office has some very helpful videos that you can watch about trademarks and not so much about copyrights. That would be Library of Commerce, which is in an entirely different branch of government from the patent office. But you should so you should go check those out. At least the trademark ones at some time. They're very, I think they're very helpful, and they're a little cheesy, but they're made by your government. So, and here's another one that I've noticed as I'm watching some newer Disney videos. I've noticed that they've started to put in a snippet from Steamboat Willie, which was their original Mickey Mouse film way back in the day. And I don't even remember when it was first released, but it's credited as being one of the earliest full-length animations in the United States, at least. And they've started to take a snippet of that with the original drawing of Mickey Mouse kind of whistling and steering the steamboat, and they put that at the beginning of their films to indicate that this is a Walt Disney production. Trademark. The full-length thing, the full-length movie of Steamboat Willie, or really any of the cells from Steamboat Willie. Steamboat Willie was first, drawn out on these very large pieces of some sort of material that they call cells. And, each one of those would by itself be an independent work of art. In fact, they're extremely valuable. Each of those has its own copyright. Now, why would Disney want to have Steamboat Willie as their trademark? Well, there are a couple reasons I can think of. One is that the trademark is perpetual as long as they've continued to use it in commerce. Whereas the copyright is good for 100 years from the date of creation for a work like Steamboat Willie, which is a work for hire. So, I'm not sure exactly when Steamboat Willie was created, but we're probably coming up on its 100-year anniversary. So you can see why Disney might want to, hang on to whatever value they can get from that original creation, because it's very valuable to them. And this is one of the ways they can do that. So that's, and I don't think there's any argument that you would see that snippet of Steamboat Willie and think of Disney, if you know anything about film anyhow. Okay. There's also an overlap between copyright and patent. I haven't included all the overlaps here, but matter that's described in a patent can be copyrighted material. There are fair use issues in here, like for instance, there are just numerous exceptions where you can make copies of patents for all sorts of reasons and not violate copyright. One of the biggest ones is that the United States Patent and Trademark Office requires the filing of patents in what they call an information disclosure statement when you file your own patent application. So if you're aware of other patents that are on the same topic, it behooves you especially if you have copies of them on your computer or something like that, it behooves you to put them in front of the examiner so that they consider, and so the examiner can consider it during patent prosecution. So your patent will be valid when it issues. That's fair use, and there are tremendous numbers of fair uses for patents. I won't even go into those at this point. In fact, there's a real good question whether as a government publication, it isn't just exempt from the patent laws or from the copyright laws altogether. But the copyright does not cover the idea expressed, if you'll remember from our previous slide, which means that disclosure in a patent doesn't negate the author's copyright. And I'm missing an apostrophe there. I apologize for that. Does not negate the author's copyright in the same original work of authorship published in a journal article or a book, or sung to the tune of Oh Susanna or something like that. You can kind of get crazy about this kind of thing, but the point is that just because it's in a patent doesn't mean that there aren't other valuable copyrights in that material, and those are protected. And we talked a little bit about how journal articles are protected in say the university setting. So let's talk a little bit about the big mistake people make. We've talked about some of the mistakes that are made, but the big one is infringement. And let's talk a little bit about that. And I'll talk about it from both sides. The defendant side mistakes, or the accused infringer type of mistakes. One mistake is that attribution is not enough. If you copied enough of somebody's material for it to be considered to be not fair use, the fact that you gave credit where credit is due, that's not enough to absolve you from copyright infringement. A real big pitfall is this inadvertent or unconscious infringement. And this kind of thing pops up in various contexts. One of them I want to talk about is a fairly famous one, but here's what I mean by inadvertent or unconscious infringement. You heard something somewhere and you unknowingly copied it. Maybe you heard somebody say something and you thought, that's really great. I'm going to use, I'm going to remember that. Then maybe later on you forgot where you heard it. And then maybe later on you forgot that you heard it anywhere, and you kind of, you just liked it so long and you start to believe it's your own. That happens. And, but here's the thing about copyright infringement. Motive doesn't matter. If you copied it, you copied it. It doesn't matter how you copied it. It doesn't mean whether you meant to copy it or not. The motive doesn't matter. Okay. Here, this is an example here. Several years ago, George Harrison got sued by the group the Chiffons. The Chiffons created He's So Fine. Apparently, along the line, George Harrison must have heard the refrain from that song and incorporated into his song My Sweet Lord. And when he testified about it and when he talked about it, and later after he was sued by the Chiffons, he acknowledged that he was familiar with the Chiffons and their song. It got a lot of radio play. He must have heard it at some time, and he had to admit that there were elements of the two songs, this kind of da 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 da, kind of repeating refrain. And they had completely different reasons for publishing the two songs, and completely probably different audiences as well, although they have both ended up on the top 40s. The fact that he didn't mean to infringe doesn't mean that he didn't infringe, and he ended up paying a lot of money for that. It's important to know that the amount copied doesn't need to be the whole work. In the case of Harrison, there were just a few bars copied. It wasn't the entire thing. And in fact, if you looked at it, you'd say, well, the arrangement's slightly, the arrangement's different. And, the lyrics are obviously different. It didn't matter. He was still liable for copyright infringement. So some more mistakes that are made is presuming something is a parody just because it makes you laugh or somebody laugh. It isn't parody just because it makes or is intended to make people laugh. That's not the definition of parody. That might be the definition of comedy, but it's not the definition of parody. Parody, parody requires that you are criticizing the thing that the thing resembles. Okay, so if you, let's say, and I'll give you an example here that I think is I'll give you a couple of examples. I'll give you an example and a counterexample here. But the thing about it is that, parody is ridicule. It's criticism. Remember, it came under that category of criticism, which is a fair use. But the ridicule needs to be aimed at the thing that is being parodied. It can't be aimed at somebody else. And I'll show you what I mean in a minute here. So the two cases are Campbell v. Acuff Rose and Dr. Seuss Enterprises v. Penguin Books. So those probably don't mean anything to you, but maybe the names Two Live Crew and Roy Orbison mean something to you. Okay, so in the Acuff Rose case, Two Live Crew used they took a sample from Roy Orbison's Pretty Woman and they looped it, and then they wrote some pretty dirty lyrics to go along with it. And Roy Orbison's family, Roy Orbison had passed on by this time. Roy Orbison's family was quite taken aback by this thing and and offended, so they sued for copyright infringement. And this was considered to be a parody of the song because the sampling and relooping and along with the dirty lyrics actually made fun of the song Pretty Woman. You may not like that. There are all sorts of reasons that I can think of not to like it, but it wasn't copyright infringement. It may have been a lot of other things, but it wasn't copyright infringement. It was fair use of the sample because it made fun of the song itself. So the parodied song made fun of the song. So that, the parody was a criticism of the song. Now, Dr. Seuss, in the Dr. Seuss case, Penguin Books was about to publish a book called The Cat Not in the Hat. And the subject of The Cat Not in the Hat was not the Cat in the Hat books. The subject of this was O.J. Simpson during the O.J. Simpson trial, if you'll remember that. So they used the likeness of O.J. Simpson, but dressed up as the Cat in the Hat, and they used other elements of Dr. Seuss's writing to parody the O.J. Simpson trial and O.J. Simpson in general. That was not a fair use. It's not a fair use. It may make you laugh, but it made fun of O.J., not the Cat in the Hat. So I hope that helps illustrate it. There are a lot of other interesting things there, but I'll leave it at that and leave you to your imagination to think of ways that one thing could be a parody, and another thing wouldn't be. Let's see. Now, here's a tricky one. This one I call not registering all the copyrightable material. And you have to remember that, let's say if you write a song, there are various ways in which that song is protected. Well, one of which is that you might write sheet music and you might protect that under copyright registration. And you might do a sound recording of it, and you can record that as under a separate copyright registration. You might include it in an anthology that gets its own copyright, et cetera, et cetera. Well, what if you register only the sheet music? Well, then only the sheet music may be used to trial to prove infringement. And the example I've got here is a case called Skidmore v. Led Zeppelin. You probably never heard of Skidmore, but you probably have heard of Led Zeppelin. In the case, what happened there was that Skidmore, the only thing he had to rely on at trial was the sheet music and not the sound recordings. And he tried like crazy to get the sound recordings in. And unfortunately, under the law that he was operating under, since he hadn't recorded since he hadn't taken an actual audio recording and registered that in the copyright office, he couldn't bring that up at trial. And he tried in all sorts of different ways to bring it up. And it just never panned out for him. So, you need to, when you look at a copyright, you need to think of the kind of the overlapping copyrights that are there and think of all the different ways. And this is especially true when you go into trial. Okay, this is more of a litigation strategy than anything else. Now, the next thing I'm going to talk about is copyright exhaustion. This one's a little tricky, and up until a few years ago, the Supreme Court hadn't really chimed in on it. It was sort of up in the air what the contours of this doctrine were. So exhaustion might just sound like I feel right now, exhausted at the end of an hour talking about copyrights, but that's not it. What it means is that you exhaust your rights once you've sold the first article, once you've sold an article that has the copyrights embodied in it. And the way I have it here is probably clear. First sale of an infringing article exhausts the copyrights owner's rights in that article. So, give you an example. I published, let's say I hire a printer to print up 1,000 books. I'm going to sell them myself. I sell you a book. You turn around and you sell it to somebody else for, let's say you mark it up. I can't come after you for any of the money that you made off of selling my book. Let's say, maybe I signed it. And so you turn around and you sell it, you bought it from me for $10, you sell it for $100. I've already been made whole. Now, the way this came up in reality and what went up to the Supreme Court was someone published books overseas and they sold them overseas. Well, we'll just say they sold them for $10. They were imported in the United States and sold for $20. Somewhere along the way, somebody pocketed some additional money. It's called margin. And they were sued for copyright infringement. And the Supreme Court said, no, when you sold that book overseas, you exhausted your copyright. It didn't matter that it was overseas. It doesn't matter if it was here in the United States. Once you sold one of those, important thing, a couple important things to keep in mind here. You can sell an article with a limited license. It's not standard in most publishing, but you could put a limit on the license for using that article. It's not entirely clear it would work. The other thing I would say about copyright exhaustion is that just because you've sold the book doesn't mean that that individual has the right to go out and make copies of the book and sell copies of the book. So you didn't lose that right. That copyright is still alive. What you can't prevent is, or you can't make any more money for, is the resale of the article. Now, here are a couple more mistakes people make. And we talked about this before, but there are overlapping copyrights oftentimes. Computers could have source code, executable code, GUIs that actually the executable code creates and uses to execute more executable code. In music, you can have sheet music, lyrics, sound recordings, digital sound recordings, things like that. So, you need to think about the different layers, and this is all very context specific. So it depends on what area you're working in. If we were working in books, there's they're the characters that are embodied in a book. Can they be used in a later series or something like that? So you need to think about those kinds of things. Don't think your idea is protected by copyright. We talked about this before. All these ideas, concepts, and processes are not they're not copyrightable. They're just common elements, and they're not copyrightable by themselves. Some of them may, like processes, be patentable, and others are just they're not protectable because they're in the public domain. And you should remember, if you're filing a patent, you need to do it in a timely manner. Copyrights, your unpublished material can sit on your computer for 10 years before you get around to publishing it, and that's just fine. Patents, on the other hand, the clock is ticking. Somebody else could file on your idea and get the patent instead of you, or you might inadvertently publish it and cause the clock to run out on you. So you need to be careful with patents on timing. Copyrights, it's more important that when you publish it, you obey the copy marking statute. So here's some mistakes on exhaustion. Most of the time you'll be selling something that has a copyright material embedded in it, like a computer with your code in it, or maybe just the code itself. It could be a book or a CD or a DVD or a digital download, a magazine webpage or something like that. You should include a copyright notice. And here's, so I included a proper copyright notice at the beginning of this work. There's no need to state that all rights are reserved. A lot of times you'll see that. You'll see the copyright owner's name, the date, in no particular order, and then you'll see all rights reserved. Well, you don't need to do that. You can, but you don't have to. It doesn't really have any legal significance. It might make you feel better, and some old school lawyers might still include it, just for safety's sake, but you don't really need to do that. And here's kind of my last caveat here is that if you're selling, let's say, a DVD and it has a limited license to it, maybe you're selling it, and the idea of selling it is to get it in as many hands as possible. So you don't mind it being copied, maybe it's just information that you want to get out there. Okay, I mean, using a DVD as an example, it could be a digital download. If you sell it without any stipulation on it, it'll be presumed that all rights are reserved. If you say, on the other hand, please show this to all your friends, blah 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 blah, then you need to put in a reservation clause that says, but please don't alter it in any way, or charge for it, or whatever limitations you want to put in there, without express written permission from the copyright owner. Put your copyright. You understand that if you say, hey, this is free for download and distribution, then, if you don't put those reservation clauses in there, people could do funky things with your stuff. And one of your rights as a copyright owner is to make derivative works. Well, you don't want somebody out there making a derivative work that's going to make you look bad. So you want to have a reservation clause in there. If you're giving it away for free, the last thing you want is somebody going out there and making money off of it. It does two things. It makes you look bad because now they're going to think that you're charging for it. And, it also, honestly, you gave it away for free for a reason. You don't want to have somebody making money off of your creation, which you intended to be free. So, so just because you're giving it away doesn't mean that you necessarily have given up all your rights. but you need to make clear what rights you're reserving. If you are reserving rights in a thing that is downloaded, or maybe you're charging it, maybe you're charging 5 cents for something, minimal. You can have a license in there and say this thing is you can distribute this thing if you want to, but you can't make money off it, something like that. So I hope this is helpful. I saw one comment, and then I saw a never mind, my question has been answered, but I'll kick it back to Julie for a moment here. In the meantime, thank you. I appreciate your attention. And again, there's my contact information down at the bottom.
Thank you, Matt. Like you said, there was a great question up here, but you did answer it in your presentation. Very interesting stuff. By the way, I love that song, My Sweet Lord. I was trying to learn to play it on the guitar. Awesome song. Thank you. Again, if anyone has any questions, you can contact Matt or you can shoot me an email. Also, we'll see you here next week, same time, same place, and we will be talking about copyright strategy next week. Thank you, Matt. You have a great week.
You too.
See you next week.
See you next week. Bye-bye.